Election laws, mail-in ballots came to the Supreme Court this week in oral arguments. Supreme Court just started their term, and sure enough, they got into politics real quick. My name is Dina Doll with the MeidasTouch Network. Let's break this down. So the case is Bost versus Illinois Board of Electors. This is about Congressman Bost. He won his election by 74%. In 2024, but he claimed that he was injured because the law in Illinois allows for the counting of mail-in ballots 14 days after the election day as enumerated in the federal law. And he says that the conflict between this law in Illinois and the federal law saying election day specifies it is unconstitutional. That's his claim. Now, his complaint was dismissed outright in the lower court before any of the motions of summary judgment or evidence presented. Right at his initial complaint, Illinois filed a motion to dismiss, saying he did not have standing. He was not harmed. Here's a candidate who won, even though the ballots were counted for 14 days after election day as specified in federal law. So even if perhaps this is unconstitutional or not unconstitutional, we don't even need to get into that part, because a foundational principle of any lawsuit is that you have to be harmed by the thing that you are alleging is wrong, or in this case, unconstitutional. And this motion to dismiss was granted in the lower courts, but the Supreme Court granted review of this claim by Congressman Bost that he did indeed have standing. And so the oral arguments in front of the Supreme Court were really focused on when can a candidate sue any election law. And the reason why this case is so important, yes, it touches on mail-in ballots. And I'm going to get into another case. There's a case out of Mississippi that the Supreme Court might also take that really centers on basically the constitutionality of counting mail-in ballots after election day. But this case, the fact that the question is, when can a candidate sue over any election law? It's broader in some ways. And what may happen if the Supreme Court justices, the conservative, or I don't even know if you want to call it conservative these days, the MAGA justices, if they decide to side with Congressman Bost and broaden the definition of when a candidate can sue any election law, you will open up the floodgates of lawsuits. If a candidate doesn't have to say that that particular law harmed him substantially, which is the current standard for standing, you have to show some sort of evidence that there was a substantial risk of harm or substantial harm by the law that was created. That way you can have your case proceed. But what Bost wants, as well, of course, as the White House filed an amicus brief in support of Congressman Bost, and not just Trump wanting this. We also see some of the the groups that have been trying to suppress the vote. Also, the amicus brief filed by the Public Interest Legal Foundation, which works to suppress the vote, essentially. Christian Adams, the founder of that, was also on a call with Trump trying to get those votes from Georgia. So this is who we have seen in support of this. So what may happen if the Supreme Court, and it did seem from oral arguments that the only justice, kind of what we've seen with other cases, the only justice that seemed a little bit less unsure of whether or not to rule in favor of Congressman Bost was Amy Coney Barrett, which we have seen her be perhaps a swing vote in certain situations. But in terms of Gorsuch, Alito, Thomas, certainly Kavanaugh as well, Chief Justice Roberts also seeming to lean that way. But Roberts and Barrett being perhaps a little bit more unclear which way they're going to rule. But if they do end up ruling in favor of Congressman Bost and give this blanket candidate standing, saying that if you are a candidate, you can have a generalized harm just by nature of being in a competition of an election. If there a rule change in that election, that is enough to give you harm, which is exactly what Bost and the others were arguing. If they give him standing for that, then you can have any candidate anywhere sue over an election law. And that includes self-declared candidates that maybe have barely any chance of ever winning, barely any chance of any backing, doing the same thing. This will open up the floodgates of lawsuits that counties, cities, states will have to then fund to defend and slow down, frankly, the process. This is how you create chaos around elections. This is how you create distrust around elections. So this is a really important case in front of the Supreme Court right now that will determine how little, frankly, a candidate will need to argue that they are impacted in a way that is harmful. He was trying to argue that, one, he had reputational harm, that yes, even though he won, again, he won by 74%, even though he won, his margin could have been higher, and that hurts his reputation. Secondly, he argued financial harm, saying that he had to hire people to observe the elections for that 14 days after the election where they could count the mail-in ballots. But he could not, according, Kagan and Sotomayor and Ketanji Brown Jackson kept bringing the argument back to whether or not he could have an articulated harm that was basically substantial enough to be able to have standing, that the court has moved away from some sort of generalized standing, saying, I think it was Justice Kagan saying, we have just decided in an earlier case that doctors don't have generalized standing, but you are asking us to give candidates generalized standing, that just by nature of being in the election is enough to sue. And really making the point too that the DNC, the RNC often are granted standing for being able to sue under election laws, and do. Justice Ketanji Brown Jackson making that argument, saying pretty much every new election law is always contested by the different parties. They are able to articulate standing in a way that has allowed all of their lawsuits to proceed. What you are asking for here is doing away with our core precedent on standing, and then also just the practical thing of this will be opening up floodgates to create more chaos. Now, as soon as I sit on my couch, I have to grab a blanket, and my favorite is the Lola blanket. It is so incredibly soft, so luxurious looking. It is not only my favorite blanket, but it is the favorite of everybody in my family. We literally fight over it. I'm not surprised. It is the world's #1 blanket because it's crafted with ultra soft luxury vegan faux fur, a signature 4-way stretch, and it is machine washable, double hemmed for durability, and stays flawless even if it's washed over and over. I have a large, and they even have an extra large, which they call the biggest blanket on the internet. And something really important to me and many other families, I'm sure, who have people affected by cancer, is that they donate a portion of their proceeds to cancer research and treatment and give away blankets called Blankets for the Brave to people living with cancer. So for a limited time, our listeners are getting a huge 35% off their entire order at lolablankets.com by using code MISTRIAL at checkout. Just head to lolablankets.com and use code MISTRIAL for 35% off. After you purchase, they will ask you where you heard about them. Please support our show and tell them we sent you. Wrap yourself in luxury with Lola blankets. Now, in terms of the actual mail-in ballot question, if they rule that this congressman has standing, then it will go back and the lower court will decide whether or not the Illinois law allowing for the 14 days for the ballots to be counted after election day can is constitutional or not constitutional. And what will happen is we will see candidates around the country do this. Now, this does not only help Republican candidates. You could have Democrat candidates in red states also now sue over different election laws. And that was another interesting thing. The League of Women Voters, obviously pro-Democrats, filed an amicus brief thinking that this was helpful to them because they could more easily contest election laws. So it will create more litigation everywhere in a way that will become chaotic, but perhaps it will be helpful to Democrats in red states where election laws are changing. And that brings us to the Mississippi case. In Mississippi, the lower court had ruled that there they can count mail-in ballots 5 days after the election. And that was contested. And there the question was the same idea, but it wasn't brought by a candidate. And that's why there wasn't the standing issue. And the lower court said that this was constitutional. The appellate court ruled that it was unconstitutional because it conflicted with federal law that determines the date of the elections. This is now, they have asked the Supreme Court to take a look at this. And the Supreme Court in their October 17th conference will determine whether or not to take this Mississippi law, which is exactly on point. The issue in front of the court will be whether or not counting ballots after election day is constitutional or not constitutional. We have seen Trump over and over and over try to say that he wants to do away with mail-in ballots. Will the Supreme Court find a way to help him do that? We are breaking this all down, not only on MeidasTouch, but Michael Popak and I break down all the Supreme Court developments on our show Unprecedented on the Legal AF channel. Be sure to check that out. And I'm just going to leave you with just a snippet of the oral argument where the give and take between the justices and Congressman Bost's lawyer, where he basically concedes that it is easier for Democrats to sue election laws because they are harming voters. It's a really interesting argument on his part, but the idea is that Democrats can sue better because it is more obvious that the election laws harm voters. But anyway, take a look because this is the crux of it. The election laws passed in red states and blue states. Blue states are trying to encourage voting. And of course, we see the red states trying to restrict voting. And that lawyer basically conceding that point. Take a listen.
Here's what I do want to say. Usually in these cases, when the party sues, they often couple themselves with a candidate or voters. And one of the things that I think is particularly problematic is you said it yourself, like there are certain of these rules that the Democrats don't like and certain of these rules that the Republicans don't like. Well, the rules that the Democrats don't like tend to operate negatively directly on voters. And so when the
Love this video? Support independent media and unlock exclusive content, ad-free videos, and custom emojis by becoming a paid member of our YouTube channel today. You can also gift memberships to others. Let's keep growing together.